If only you were here. Everything is fallen apart. Dad knows. I told him. He just flipped. He couldn't just take it. It was a blunder to tell him about this in your absence. I'm so shattered. He didn't budge. He's so full of himself and his social standing. I was so wrong to presume when the law changes we could be free. For Dad, it's just a shame that his son is gay. He almost killed me, you know. I think he will. He was raving mad. He strangled me like a madman. I could not breathe. He kept cursing me all the time. He left screaming, threatening to kill me. I will not let you tarnish our family's name and pride. Ma, I'm trembling as I write this. Dad will kill me for sure. Little did I know if my homosexuality is tolerable to the law, it changes nothing right here in our homes and our society. People like Dad will never let us live free. For them, we are freaks who deserve no mercy. I am certain he will kill me. I must escape before he returns with his mad fits. They say, he who fights and runs away lives to fight another day. I could not put up a brave fight. I don't know if I will survive if I run away. I am very afraid. Pray for me. I have to run far away. Yours.
We have two pieces of evidence in this case. The first piece of evidence, which is crucial for us, is the letter written by Rohan to his mother, very apprehensive and apprehension, and that is written shortly before and is indicative of the fact that his father is likely to do harm to him, and therefore, in my view, that can be safely considered as a dying declaration, as also evidence of his conduct prior to the event, and therefore that can be used to prosecute and seek a conviction. Apart from this, we had the statement of Rahil, who is since turned hostile and not supported. Now, this statement, and if there is something in this statement which A, indicates the prior incident when the father confronted the young man, as a result of which the letter was written, and if there are certain elements which establish some is supportive and corroborative of the dying declaration, then those elements can also be used, because the testimony of a hostile witness cannot necessarily be completely discarded. That was a principle that was followed 30 odd years ago. Today, a testimony of a hostile witness can be used. But having said that, we will also need to establish through forensic evidence that the weapon that was discharged was the one that has caused the death, and we will have to link it, because for us, we are suffering from the loss of the most important witness, which is the eyewitness who's turned hostile. Now, we must understand this, that our court system places great relevance and emphasis on the oral and ocular evidence, and they believe that, and they put it at a higher pedestal. That being the position, Rahil's turning hostile is definitely going to damage and detract from the prosecution case, but with a combination of factors, we should be able to press for a conviction.
but in a given case, there are a lot of factors which go into anything. You have to examine also the fact whether the letter which was sent, what kind of a mindset that boy was, what kind of a person he was, whether he was a weak, as a character, a weak person, then anything could upset him. Anything could feel or create that paranoia that I am likely to be killed. Whether the father was arrested from the spot, whether the weapon was found from him, whether the weapon found from him matched with the bullets in the son's body, where he procured, what was the timing involved in it, the so-called eyewitness, whether he is actually an eyewitness or there is a possibility that he is an implanted eyewitness by the prosecution. All these factors have to be seen. I don't feel that simpliciter, a letter written in advance, is sufficient for causing conviction of any person. And as far as the hostile witnesses are concerned, their hostility also has to be seen in the evidence, whether he explains his why he is not towing the line of the prosecution. It could be possibly that he never gave that statement, and he could have been just put in, because 161 statements don't require any signatures. Did the prosecution ever even venture to get his 164 statement recorded before a magistrate? Because a hostile witness under 154 of Evidence Act would only be if he is not towing the line of what he should have, and there is a reason which is what we call an unholy alliance of money and power to corrupt the witnesses. But is it so? Or is it like the prosecution has simpliciter found a convenient witness to be planted at that spot to be shown as an eyewitness, and he actually has not seen anything? So to attribute murder to him, you need to have much more cogent evidence than just one letter. As a defense counsel, one might have to examine also a scene that perhaps the partner himself could have been the cause, or there could have been a cause by somebody else who liked that same partner. So it could be a triangle. Admissibility doesn't govern its trustworthiness or reliability, because conviction happens not on merely an evidence being admissible, but it has to prove beyond reasonable doubt that the act was committed by the person.
The entire basis for the principle of dying declaration, its reliability, is based on the fact that a person on his deathbed is unlikely to speak a lie. He is unlikely to spare a person who caused his death. Though there have been rare instances where a person who is dying has tried to frame, particularly in matrimonial offences, but by and large, the principle is that the person on his deathbed is unlikely to tell a lie, and it is also settled law that it can be the sole basis of convicting a person in dying declaration. Usually, dying declaration, ideally, if possible, should be recorded by a magistrate. Otherwise, the doctor, if he gives supporting evidence that the victim was in a fit state of mind and body to give dying declaration, that would be sufficient. In the present case, whether the letter sent by Rohan to his mother can be considered a dying declaration, the answer has to be yes. Dying declaration, there is no defined definition. As far as the court is satisfied that it is reliable and the person who made it was in control of his senses at the time it was made, so it can be considered a dying declaration, as long as the court is convinced that it's reliable and reasonable to believe it. Furthermore, your other question is, can this evidence be conclusive in convicting Rajesh? in these circumstances, yes, the hostility of the witness Rahil is not necessarily an impediment in convicting the father, because of the reason the person he was in relationship. It's obvious that there were family pressures after the death, and therefore he has decided to back out of his statements. In fact, a hostile witness can be cross-examined by the prosecution itself with the leave of the court. So it's not clear whether that was done or not. That can be done to elicit certain facts. Furthermore, the fact that there is a difference in time between the dying declaration and death, the law is well settled. It need not be immediate. It has to be proximate in the sense, and up to 3 to 4 months also have been considered to be, yes, that period may not detract from the efficacy of the dying declaration. So I think it's a case for conviction of Rajesh for murder and appropriate punishment under Section 302.